Greetings, distinguished guests, colleagues, and friends. My name is Pam Harris, and I am the current president of the International Association for Court Administration, IACA, and I will be moderating this event today. Before I get started, we have interpretation available for our Ukrainian participants. Please press the interpretation button on the lower part of your screen to access that function. Also, presentations are translated in Ukrainian and can be found in the chat function and downloaded. It is a pleasure to welcome all of you to our second of 4 webinars that IACA and EU Pravo-Justice will be hosting this year. Today, we will be focusing on modern methods of assessing the effectiveness of courts. If you are joining us again or for the first time, we are confident that this webinar will provide valuable insight to 4 beneficial practices. First, best practices for optimizing case processing. Second, measuring the speed and quality of case handling. Third, data-driven insights and analysis for improving case management. And fourth, the role of digital tools and software in case management. Now some housekeeping details. This session will be available later on YouTube. Please subscribe to IACA's YouTube channel so you will be notified when the video is uploaded. It takes a little while. That link has been posted in the chat feature, or you can also find a link on IACA's website once the video has been uploaded. If during this session you have any questions, please use the chat function and we will make every effort to get to those questions at the end. We are thrilled to have over 400 attendees registered here today. All of you representing a diverse group of professionals committed to strengthening and enhancing your judiciary's ability to serve your communities. And so many of you in the most challenging of times, war times, where many of us cannot even fathom how you continue to do this most crucially important work. But please know, it is fundamentally necessary and appreciated by those needing legal assistance or legal resolutions. As we all know, courts are at the very heart of ensuring justice, and it is you, the people who work within the courts, that enable this vital service to function properly. However, the complexities of modern-day challenges, whether in the form of political, economic, health-related emergency, or especially in wartime for our Ukrainian participants, have all placed an immense strain on the workforce. This webinar will focus on how we can address some of these pressures by exploring innovative and practical solutions for some of the most pressing issues facing courts everywhere around the globe: effective case management. This webinar aims not only to provide insights into case management, but also to share inspiring accounts from our speakers about how to overcome case management challenges. It's a time for learning and for reaffirming our commitment, your commitment, to assure that our courts are administered efficiently and effectively for the people we serve. Thank you for being here, and I look forward to a productive and inspiring webinar. Now, please welcome Ola Bulga, Deputy Head of the State Judicial Administration of Ukraine, who is very familiar with this topic today. Ola, it's all yours.
Доброго дня, шановні колеги. Насамперед дякую нашим партнерам.
Good afternoon, dear colleagues. In the first place, I would like to express our gratitude to our international partners for having organized this event. The topics and problematic issues we are going to touch upon today are very important and topical for Ukraine. Our performance assessment system implementation in Ukraine has been on the agenda since 2009. There were several waves of the implementation of that system. There were various approaches which were offered in the framework of that effort. Back in 2016, two two assessment modules have been developed and implemented as our first components of the performance assessment system. Later on, the Council of Judges of Ukraine adopted and introduced the performance assessment system in all courts across Ukraine. The performance assessment system is aimed at increasing effectiveness and efficiency of case consideration in courts all over the country. Some performance indicators have been developed in the framework of the said effort, such as average number of cases considered by one judge, average speed of case consideration, and so on. The respective data are available on the official website of the Ukrainian judiciary and is accessible in a real time at any moment in time to any person interested. Once again, I would like to express our deepest appreciation for organizing such events, for making them available to the wide public and for raising the most important issues related to court administration. I would like also to say the words of gratitude to the armed forces of Ukraine, whose immense efforts make this event possible to hold. Thank you very much.
Thank you, Olha. And indeed, we all hope and pray for the armed forces and for the people in the Ukraine. Now, please welcome Oksana Simbrivska, the team leader of the EU Project Pravo-Justice. Please, Oksana.
Дуже дякую, пані Памело. Для мене велика честь бути присутньою на цьому заході. Dear colleagues, it's a pleasure to be at this webinar, which is very topical for Ukraine and for Ukrainian judiciary. I would like to underline that the efficiency of court operation is not only about proper internal management of courts, but also about strengthening public trust in the judiciary and in the state power in general. We all understand that Ukraine is currently going through a very hard period of its history, despite the fact that the judiciary in Ukraine has been operating properly over the last years. It still happens in the conditions of war. So despite all efforts applied by Ukrainian judiciary, despite the fact that Ukraine continues its European integration path, the external conditions are extremely unfavorable. That is why, under such circumstances, it is of particular importance to provide courts with some effective instruments which would allow increasing their performance and providing better services of better quality to Ukrainian citizens. EU Project Pravo-Justice has been contributing to the development of internal capacity of Ukrainian courts and enhancing the capacity of Ukrainian courts all over the country. we understand that in the 21st century, one cannot talk about performance without mentioning digital instruments, IT instruments, which give a basis for some decision making and for purposes of court management. We are very much pleased and honored to have IACA as co-organizers of our today's event. The association accumulates best international practices in the area of court administration. That is why it is particularly valuable for representatives of Ukrainian judiciary to be able to have this insight from the association representatives and to be inspired by best practices applied all over the world. I truly hope you will learn a lot of important and practical tips and acquire knowledge which would allow you to better contribute to the enhancement of performance of Ukrainian judiciary and as a consequence will speed up the European integration path of Ukraine. I wish you all the best and good luck and thank you.
Thank you, Oksana. Thank you so much. And IACA is also privileged to partner with EU Pravo-Justice and in the hopes of doing greater things for all of courts everywhere. As a reminder, and in an effort to save precious time, our presenters' bios can be found in your materials. I assure you that you will find each of these individuals are very accomplished and experts in their field. And some of you may already know them from their previous work or current work in the Ukraine. Now, for our initial segment today, we are going to start with best practices for optimizing case processing with Tim Dibble, the Vice President of the Justice Management Institute in the United States, an Associate Professor at Michigan State University. Tim, the floor is yours.
Thank you, Pam, and thank you, Oksana, and thank you, Olya, for your introductions and for your kind words. And as Pam has indicated, we in the United States are always thinking about our Ukrainian friends and the folks working in Ukraine and the struggles and difficulties that you're facing right now. My experience in Ukraine has been for quite a number of years, up until about 2 months ago. We had a number of projects in Ukraine. We had a project, a long-term 5-year project in Sri Lanka. And up until about a year ago, we're working in Myanmar before the coup d'etat and also after the coup d'etat with the National Unity Government, which was not working from within the country. Our experience in Ukraine has been absolutely amazing, and we are really quite sad and upset and distressed in some ways at the Justice Management Institute that our work in Ukraine was stopped a couple of months ago. I am joined by Vaida, who will be doing the section on measuring the speed and quality of case handling, the second one after I speak. And then after that, I will be doing the data-driven insights and analysis. And then Vaida, again, will be leading the section on role of digital tools and software in case management. We're going to start with best practices. Hopefully we get this done in about 20 minutes. I'm going to set my timer. And when we talk about best practices, we're really talking about an overview about what are the components or elements that are important in a court and a justice system for effective case processing. This is a way of sort of stepping back and looking at case processing and assessing effectiveness of courts from a much higher level. We think of this in some respects as the culture or the legal culture of the court and the justice system in any country or in any jurisdiction. So we're going to do this today quickly in 4 sections. The first is defining what we mean by effective case processing. It seems self-evident, but I think it's important to sort of define the terms and the expectations we have for what we mean by that. And then within that, we will talk about the 3 basic elements that make for an effective court culture or legal culture in any country or in any jurisdiction. Those 3 are leadership by the courts. There are a lot of stakeholders and actors in the courts, and the key element here is the leadership of the court. The standards, so we define common goals and expectations, and then data and information to help judges and court administrators, chiefs of staff, manage their cases, as well as the court to manage the cases in the community, and then ultimately the state judicial administration or the state court administration to knit that all together into a cohesive culture and organization. So we start with the definition. Again, I'm going to read this. Don't often read slides, but case processing is the court supervision of the progress of all cases filed in that court. Again, this seems self-evident, but the idea that the court supervises the progress of cases runs up against some difficult realities for courts and judges. It's not just the reality of the fact that often courts are overwhelmed, especially if there are outside events that happen like war or the pandemic that impact courts, but also the basic human and organizational challenge of a judge having 800 cases filed and assigned to that judge in any given year, or 1,000 cases, depending on the case type and the complexity. When you have 800 cases, the tendency on the part of humans is to react on the bench and to rely on the lawyers and the litigants in the court to manage their own case. They know their cases better than I do as a judge, and the tendency is to be reactive instead of proactive. And case processing is what are the ways in which judges and the managerial staff, the chiefs of staff in each court, and the registrars and clerks, what ways can they support the court to effectively supervise the progress of cases? Consistent with what I've just been describing, it is so important to see this as what the court is doing is working within a larger justice system, and that justice system exists in a larger community, the community of people that are using the court, who are litigants or defendants in a criminal case or the accused, as well as a system of other stakeholders and funders of the work of the judiciary and of the court. The basic high-level goals we think about is at the beginning, accountability. Accountability to whom? There are a lot of folks in the system, a lot of agencies that are to whom we are accountable, but first and foremost, we're accountable to the public, to the citizens and the people in our community. But just as important, the courts are accountable for performance to the funders, to the parliament, to the legislature, for accountability for the use of public funds and revenues for the work that they're doing. They're also accountable to each other and to the other justice system stakeholders, like the lawyers, like the prosecutors, like the law enforcement, like those working in the civil systems. The second really important goal is regularity and predictability. These terms really are speaking to fairness, and the fairness is very much about for whom, and the fairness at its core is fairness for the litigants, the accused, the defendants in the courtroom. Consistent case management speaks to the idea that, one, that we have standards and measures by which we define what good case management is, but also that we have the tools and techniques that judges and chiefs of staff need to be able to manage cases. We can get a little bit more into that because it doesn't always necessarily mean automation. And then finally, reduction of backlog as a high-level goal. We didn't think of this as much historically until we started to create standards for what delay means. So backlog are cases that begin to be delayed in terms of getting older than the expectations and goals we have for how long a case needs and should take. Check my timer to see where I am here. The three pillars of case processing, and this really comes out of work that's been done by others in the judiciary, both in the EU and the United States for decades, is first and foremost leadership by the court. We talked about this earlier in terms of court supervision, but the leadership happens at multiple levels. So at the state level, the state judicial administration or the state court administration, at the court level by the chief judge and the chiefs of staff and the leadership, managerial leadership that support the judges in the court, and by the judge themselves. The judge in the courtroom, she or he, are the leaders of the management of cases and the expectations in the courtroom. We also need standards and performance measures. These absolutely are critical to understanding and expecting from each other the kinds of performance that go beyond the stylistic differences between judges and courts. And then finally, information and data. And information and data are what we need to be able to manage cases, to be able to understand how we're doing in the context of the larger goals, and also to tell a story about where we've been and where we're going. As an example of this, in the EU, they use standards based on the age of cases that is defined by a median, defined by what is the center norm across all of the European Union countries. In the United States and other British common law countries, we use a time standard that we define as the longest case. And the longest case we don't define as the longest per se, but the 98th percentile, and we'll talk about that some more later. So coming back to the issue of leadership, first pillar of effective case processing, it starts at the top with the standards and policies being set by the bench at the top end of the appellate of the highest court in each country and each jurisdiction. And it moves its way down through to the judges in each court and to each courthouse. In addition, we think about judicial administration and the support they provide to the judges to effectively manage their cases. And the idea of an executive team is something that has been talked a lot about in the last 10 years in the United States. It's something that we talk about in our work in other countries. The executive team in any court is the chief judge, the chief of staff, the court administrator, and the clerk or registrar. This concept is often difficult in courts around the world because the clerk and registrar are considered to be more bureaucratic or functionaries. They're managing often the technology, the IT system, and they enter data. But if you think about the role of the registrar in intake, in receiving cases, in filtering the adequacy of, for instance, the filing of a complaint, the role starts to become really integrated into the policies and procedures that the judge and the administrators are setting. Setting the tone and commitment these are effective qualities of good leadership. Establishing policy court-wide, but also the policy that is court-wide really needs to be understood and bought into by the lawyers practicing in that court. And then establishing partnerships with other justice system stakeholders. So we have an example of this from my work in the Philadelphia courts in terms of establishing partnerships. We've seen this also in Sri Lanka. We used to have a problem with police witnesses coming in on early appearances and even on trials to be a witness on a criminal case. And so what we did was worked out a system with the local police that we would organize the police witnesses during their actual working hours rather than in a day that they were not scheduled to be working in their community, and had them come down to the courthouse and walk a beat around the courthouse, and we would send them back then we used to have the beepers to send them to come into court when their case was being called. In Sri Lanka, they often organized the criminal hearings around police precincts. So one police district would have all their cases on Tuesday and another police district on Wednesday, so that the police district and the courts could organize the appearances and move cases forward. Courts have leadership failures because of the lack of leadership skills. Often chief judges don't necessarily get a lot of training to become a leader and manager. Often chief judges don't necessarily have the disposition to be effective leaders. There's often a lack of willingness to lead because courts are often seen as a group of equals to each other. There's often frequent changes of leadership, rotations, and we've seen this in courts all around the world. And then there is often a resistance by the judges on the bench to be led. This is related to the judge's perception of their decision-making being autonomous, and that's a legitimate concern. And the other one that we hear all the time is justice is not efficiency. So you are imposing efficiency measures on us. And then the judge as a leader in their courtroom. There are a lot of actors and stakeholders on a court in a case that are wanting to have strong influence on what's happening on that case. And the judge as a leader is the one who is both a neutral party and the decision maker about the events leading up to an effective trial, leading up to the way in which the case progresses. And we think of this in terms of 5 principles. And we use the strong word control, early control, continuous control on a short schedule. We'll talk a little bit more about what that means. Be reasonably arbitrary. That seems self-evident. And create the expectation and reality that events happen when scheduled. So the short schedule is something we see a lot in civil law jurisdictions, where trials are not day-to-day like they are in British common law. And so the short schedule is something that we've encouraged successfully judges to set trial dates very close together so that the trial can be effectively done much more quickly. 3 axioms. All of the parties in the case, including the litigants, attorneys, and judges, settle or resolve cases. Many cases are settled in civil and family law when they're not contested or when the parties can agree. They resolve cases when they're prepared, when they understand their own case and the strategy and case from the other side, when they listen to each other. And litigants and attorneys prepare for significant events. This means that they're coming into the courtroom prepared and ready to move to the next phase of a case. And so those axioms are very important. We could go into an example of a significant event, but the one that really stands out to us is if a judge sets 10 cases for trial today, and everybody knows that that judge is only going to reach 5 cases, there are usually at least half the lawyers walking into the courtroom unprepared because they know that they will be able to get a continuance or postponement very easily. So these are examples of ways in which the opposite of this axiom can undermine the progress of moving cases. As an example, we're moving now to standards and performance measures. This is just going to be a high-level review of what we mean by this. The fundamental core always are the rules of procedure in any country. So this is a diagram of the Ukraine Criminal Procedure Code, and there are a lot of really good guidelines within statutes and codes that define expectations in terms of how long these events should take. But what we discovered is that the trial itself is defined by the term reasonable time. So what happens in a legal culture and court culture and organization is that the definition or how we define these expectations are now have to supplement the rules of procedure that court has. And another example, this is the first half of what we just saw. This statute set very specific timeframes for different kinds of criminal cases at the investigation stage. There's so much to be discussed about that particular issue, but we're going to move a little bit more quickly here. And then we talk about regularity and predictability. We said we introduced earlier the idea of early and continuous control, early intervention by the court, and establishing meaningful events. In a lot of courts, this is done by scheduling order. Scheduling orders are not useful in all case types, but in cases that are contested or that have a lot of complexity, scheduling orders, stopping and thinking through what's going to happen on this case with the lawyers and the litigants is a very effective way of managing that case. For short cases that aren't contested or only take 1 or 2 court events, establishing a scheduling order is sometimes not a useful use of time. Then at the very highest level, standards and performance measures are really what is so important to underlie everything that we're doing is our accountability to the public. And Tom Tyler came up with these 4 basic measures of procedural justice: respect and dignity, court being trustworthy and neutral is very important from the perspective of litigants. And there's so much to discuss about how we're seeing the way in which the public uses the courts or comes to the court to resolve disputes and civil and family cases as indicative of their views of the court. And then the voice. Litigants feeling like they have a role in the process of litigation and that the judge and the courts have heard them. We are going to summarize with 8 examples of performance measures. These come from 3 different major sources: Court Tools, which is the basic American set of standards for performance measures for courts; the International Framework for Court Excellence, which is supported by IACA and also endorsed by a lot of Western courts; and CEPEJ, which are the measures used by the European Union. The time standards is fairly unique to the American system, and the difference is that CEPEJ and other measures are really related to looking at the median case time. We're not going to go through all of these because this is going to be introduced in more detail in very short order here. But one of the most important things about information and data is being able to tell a story from the information and data. So we're going to use an example of that. After the pandemic in the United States, we discovered in a lot of cities, urban jurisdictions, that crime was going up in very specific categories. And we didn't understand that. It was a mystery. And this was very consistent. There was 2 specific categories of violent crime. And then other ones it wasn't. It was declining or it was flat. And to us, to this day, it's still a mystery. It's a story we tell using data. And then this is another story we tell. We looked at, this is Atlanta, Fulton County, Georgia. Filings and dispositions, the lighter color is filings and the dispositions are the darker color. And the story that we can tell from this kind of data is averaged out at the end of the year. But what happens in each month and what happens across the 9-month period we're looking at here is quite different from month to month. And so we tell the story when we discuss this data with judges about how the filings have increased. Almost done here, Pam. The filings have increased by 3%. I hit my 20-minute mark. The filings have increased by 3% over the course of that 9 months. The bench is sort of keeping up, although of course, their pending caseload increased by 143 cases across 20 judges. What we discovered was that July is when a lot of them take vacations. and then they recover in August. So the data is really important because it helps us. We can look at this data and describe for the bench and for the judges what it is they've been doing over the course of the year by being able to track it like this. But the outcomes are where this really starts to hit home. And that is, as your pending caseload increases, so do the cases. These are serious criminal cases. So does the number of cases that are old increase.
Tim, I'm
Yes.
going to have to stop you.
Okay.
And
We'll come back to some of this here in a minute, and I'm going to turn it over to Vida for section number 2 on measuring the speed and quality of case handling. Thank you.
Good afternoon, everybody. It's a pleasure for me to join you for the second online seminar or webinar for discussing how to increase the effectiveness of the judiciary. I am Vida Petravitina from Lithuania. I work with the Pravo-Justice team as an expert, and also I am a member of the National Courts Administration in Lithuania. So I had the privilege during the last 10 years to work with various courts initiatives, structural reforms, performance management, digitalization processes. And today, during the coming 20 minutes, I would like to share some insights how the measuring of the speed and quality of case handling might be implemented, what European and national practices exist, and also what strategic decisions can be made after having such results. So, during my presentation, I would like to introduce the European standards for evaluating court performance, specifically the CEPEJ methodology, and emphasize the importance of establishing and maintaining national standards tailored to the specific needs of a particular judiciary. CEPEJ is the European Commission for the Efficiency of Justice, was established by the Council of Europe in 2002. Its mission is to promote efficiency, fairness, and accessibility within judicial systems across Europe. This methodology is widely recognized and applies to identify systemic bottlenecks and improve case flow management. Due to the specific data collection principles, CEPEJ reflects data that is typically 2 years old. And the most recent edition published last year included statistics from 2020. While such long-term data is highly valuable for monitoring broader trends and forming long-term strategies, national judicial systems require to have national standards for measuring particular indicators of the court performance. This real-time analysis, I may say so, will lead to more constructive and efficient operational decision-making and the decisions which are necessary for the particular judiciary. But despite the measurement methodology, there are a few preconditions which must be in place in order to ensure the reliability of both data and its analysis. First, clear legal data entry frameworks. Tim has already shared some helpful examples showing how codified rules set out timeframes for procedural actions. But in practice, that's not always the case. And actually, there is a criteria, the reasonable time. So how to evaluate this reasonable time? The Lithuania judiciary has developed a structural data approach. This means that the judiciary, during the examination of the case, marks particular agreed events within the procedure and allows the administrators or the other people using data to calculate specific performance indicators. So Tim said, data to tell the story. So this is the way data to tell a story. But this data collection cannot be diverse depending on the course. It must be standardized for a group of course, for an instance, in order to be able to, for the administrators or the other interested parties to compare with data existing or collected by different cores. Without standardized input, the analysis can be trusted and any conclusions drawn may be misleading. Digitalization, IT equipment are the instrument to have the properly collected and the data which is reliable. So having one common database within an instance of course or over a whole judiciary will ensure that the data collected by the same criteria will be stored in one resource and used for using the same functionalities and processes. And the fourth very important, and from my personal perspective, the most important thing for having or creating data culture is the knowledge and clarity of roles in the process of entering data. Judges and court staff need to clearly understand what data must be classified and how, but it's equally important to assign the right responsibilities. The court staff it's recommended for the court staff to be responsible for the data collecting process. Judges should not be burned with this administrative task. But in order to be able for the court clerks to work with data, the classification should not be complex and should not discourage people to work with it. Trainings also are very important in this procedure, and only regular trainings will provide the ensure consistency and accuracy in collecting data. And commitment and or obligation to collect data is also are also very important, because only without general commitment or without obligation to have the full extent of data will be quite challenging. While measuring the case handling, but supervision methodology focuses on two primary aspects of case handling: speed and quality. Speed ensures that cases are resolved in a reasonable time frame, while quality ensures decisions are fair and transparent. Both these criteria are based on data-driven approach, but using specific performance indicators. Speed, the first one and very important. Speed is a key factor in judicial efficiency. Supervision methodology uses four main indicators to measure it. Disposition time. Disposition time, this is an indicator which shows the average time it takes for a court to resolve a case. It's calculated by dividing the number of pending cases by the number of resolved cases, and then multiplying by the annual number of days within a year. A lower disposition time usually means faster case resolution. Clearance rate is the other indicator which compares the number of resolved cases to the number of new incoming cases over a specific period. A rate of 100 means that the court is keeping calm. It resolves all cases received during the which are received during the reporting period. Higher than 100% indicates backlog reduction. That's a good sign for the judicial efficiency. Below 100 suggests backlog growth. This is a warning for the system to pay attention whether additional actions are needed in order to increase the efficiency of the judiciary. Case turnover ratio is a criteria which is not so widely used. This ratio measures the relation between the number of resolved cases and the number of unresolved cases. And the backlog ratio is the fourth criteria of a methodology, which shows which measures the share of unresolved cases that have exceeded a certain age. This means that how many cases have been prolonged, which duration exceeded more than 1 or 2 years. It reflects the court's ability to deal with all the cases. A high backlog ratio points the necessity to important structural or some organizational changes, because with the high rate of backlog ratio, the efficiency of judiciary seems to be not enough. Well, from the national practice, I would like to share with you that the difference between the methodologies and which one would be more useful for the national judiciaries. The disposition, as I mentioned earlier, says that disposition time is calculated by dividing the number of pending cases by the number of resolved cases, and then multiplying by the annual number of days. But while working with judiciary, we've noticed that it's important for judicial administration to calculate and to compare how long it actually takes to process a case on average. And this should be done by specific categories of cases and procedures to provide more meaningful insights. If there are time limits for adjudication of particular group of cases, the examination of the rest of cases will remain in the hands of judiciary. For example, in Lithuania, the judiciary assesses annual case processing duration by calculating the average number of days from the submission of the initiating document to the final procedural decision. This metric shows us how long on average cases are being examined across a particular instance of course. Importantly, this data also helps identify where procedural delays occurs and what targeted actions might be needed to streamline the process. When we find the delays in the examination of cases, the Lithuanian judiciary have a practice to collect and examine specific data points that show why these cases have been prolonged. And these insights are very essential for identifying patterns and developing targeted solutions. Some of the common reasons which are being tracked during the most recent periods include that requests of a party for adjournment of a hearing, a revised or amended claim filed, how often parties to the proceedings fail to attend a court hearing, also how the involvement of other persons affected the proceedings. One more very important reason for the prolonged case examination is the changes of the judge or the panel hearing the case. So having these metrics, the judiciary may understand why delays happen and plan targeted actions to tackle this issue. How the evaluation of delays is implemented. So courts indicate what particular causes of delay were present in a particular prolonged cases, and having this data, an evaluation is carried out to determine the most frequent case ratio among these prolonged cases. In other words, the judiciary identifies the most common causes of delay and how often calculates how often they occurred. This kind of analysis is incredibly valued. It provides a clear evidence base for administrators to decide which actions are necessary to accelerate procedures. And also, this data plays a crucial role in the public communication and is very highly relevant for our policymakers because having such detailed data, the more targeted legislative initiatives or reforms might be implemented. While analyzing the speed of resolution of case examination, it's very important to look beyond the numbers and consider the complexity of cases and what procedural forms available within a legal system. In most EU countries, simplified procedures, especially in civil cases, are widely used. The usage of such procedures might change the general duration of the case examinations. For any meaningful forecasting and analysis of how long preliminary examinations or trials may take, we need to evaluate the duration of proceedings based on case categories or complexity. Measuring the complexity is really broad and detailed topic, and I won't go in it in detail, but I would like to emphasize a few key principles that any complexity evaluation system must be standards across a group of courts. It should be explicit and understandable for those who enter the data. And the complexity evaluation system must have clear restrictions and safeguards in place. For instance, like organizational rules that who is responsible for entering data, when data can be entered, and under what conditions it can be modified. Legal agreements that define the framework for using such evaluations, when the complexity of cases might be used as such. And importantly, IT solutions that ensure data is collection transparently and reliable. And when having this quantitative criteria like a speed of case examination, the CPEJ methodology says that speed is not alone is enough. Courts must also ensure fairness, transparency, and consistency in decision-making. So the methodology entails such criteria for quality evaluation like judicial independence, and the analysis of judicial independence entails various aspects, such as appointment of judicial core, budgeting of judiciary, trainings provided for the judiciary, whether other sources are sufficient for the effective operation of the judiciary system. So the broad scope of criteria are evaluated under this indicator. One more very important aspect of the methodology and the CPEJ Commission is that the use of digital system. There is a common agreement that the digitalization processes ensures the higher efficiency of the judiciary system. So that's why it's very important to pay a high attention for installing and promoting digitalization processes. But the last year, the CPEJ passed observation that some countries score a high score in deployment of information technologies, but very low score in usage of such technology. So these are two different indicators. That is not enough to have technology and to say that it's installed in all countries or in all courts within all the state, but also that these technologies are in use. And also a new approach is that the judiciaries should face an AI, artificial intelligence, and how these technologies might put impact on the making judiciaries work more efficiently. And a few more last aspects, and I will finish in 2 minutes. So this is that while evaluating the quality of the judiciary, it's very important to have the understanding of the public trust, and this public trust is evaluated via the access to justice in various aspects. how information of a legal system, of possibilities to apply to court and etc. is accessible for the common society, the digital accessibility possibilities. Also, the methodology says that judiciary should have user certification services in order to overlook their efficiency and to come to particular decisions. Few more points of a European perspective is that it's very important to see how the legal aid system is implemented within a state. Maybe it's not the responsibility of the judiciary as itself, but it's the common approach of the state ensuring the security and standards for all groups of people applying to court. And also the protection of vulnerable groups is one of the axes the Separation Commission evaluates during its report. Consistent of decision is according to the Commission, and the methodology says that it's very important to see that the similar cases, the similar outcomes will be in the similar type of cases, to see the consistency and decisions, but and this consistency also shows the quality of decisions, of the quality of the judicial systems. So in Lithuania, there is a practice to measure the quality of decisions, calculating on how many court decisions have been changed or annulled during the appeal procedure. So that my time is over from your thesis, so I will have few suggestions for how to use this data in actions, so that I may just leave it for the other presentations and for the other presentations. So and to tell there. So thank you.
Thank you so much, Vida. You've heard from Tim that some have indicated justice is not efficiency. And you've also heard Vida allude to other important factors on delay, but I wanna just give one saying out that I know all of you have heard, and that is justice delayed is justice denied. So our next session is data-driven insights and analysis for improving case management, and we're moving back to Tim Dibble to address this area of interest. Tim.
Thank you, Pam and Vida. It is, can I get this up? In looking at data-driven insights and analysis, one of the things that struck me about, and we've been watching this for years, the CEPEJ measurements and what Vida just talked about, is they do a really good job of looking at how much each country invests in prosecution and legal aid in defense, and the resources that are balanced between the two interested parties in any case. And we think that I personally and professionally think that's a phenomenal measure. We don't do that well in the US and other British common law countries. So we're going to move pretty fast through this presentation about data-driven insights and analysis. And it feels a little bit like getting hit with a fire hose because there is so much to cover. But before we look at the broader set of performance measures that we see in other toolkits for court and for each case, just wanted to talk a little bit about statistical information and balanced workload, because this is such an important issue that we see in courts all over the world. We really, as humans, especially moderns, we classify everything. So I can vegetables and grow them, and we can them in like-minded jars because they react the same or differently from each other. But that's a way of classifying things. And it's so important when thinking about how we measure that what is being counted is agreed upon, all the way down to the level of the clerk or the registrar entering data on a case. It's really the most effective way of understanding that what's happening in this court is similar to what's happening in this court. And we see this all the time when judges say, well, we can't rely on the data because of bad data entry or errors, or differences in the way things are counted. So we talk about data definitions. We had worked with the Maryland courts. Pam used to be the state court administrator in Maryland. And one of the things they did at the very beginning of digitization of the court statewide was to create a data dictionary to define what a criminal case is and what a civil and family case is. And where this is really relevant, and I'll just use one example from each. In criminal cases, is the investigation phase a true part of the court case? In European countries, it is. It's the investigation phase of a case, but often the formal charges aren't filed and we don't really start counting it as a case until it's moved to the charging phase and the trial phase. In civil and family cases, how we measure civil and family cases is often with one standard. Vida just referenced this. But at the same time, there is a strong impulse on the part of courts to distinguish between a contested and an uncontested case. And we don't always know that an uncontested case or a case that it can be settled is that kind of case at the beginning. Often the lawyers do know, but these are the kinds of definitions that's important to establish in the court and among the stakeholders in the court. Other definitions that are critical is what starts a case. We've talked about that in terms of filings. That's not usually something that is disagreed upon, but also terminations or end of a case. And this is something we still have issues and discuss with courts all over the world, even in courts with a lot of good technology. It's important to understand how many cases are resolved by what means. And so we count these things and measure them by these different types of ways the case is resolved, because it's hugely important information for judges and the parties in a case to understand how we move a case to settlement if it's likely to go there, or what happens when we contest a case, why are cases dismissed or withdrawn. And then also, the other huge definition issue is interesting and somewhat controversial, is once a case has gone to judgment or final order, what happens after that when you're in what in American courts we call the enforcement phase? In a lot of courts, that case is still considered open. And it's an interesting issue, but it's very important to understand the difference between a case that is in the enforcement phase versus one where the causes of action, the issues have been resolved. These standards are really important to also help standardize the language we use. So when we've been working in Sri Lanka for 4 or 5 years, and we found that there was terminology used about different phases of a case that overlapped. And talking about it in a way, because this is just the way that the conventions that the judges and the lawyers used. And then even defining what starts a case in terms of the court's ownership of the case. As in this example, jurisdiction really doesn't start until you have another party. You can get a default judgment against somebody at that point, even if they don't respond, answer, or show up to court. But you don't really have a case until you have a party. The same kinds of thinking apply to criminal cases. And then we talk about balanced workload and how we count things, because counting things is incredibly important when we start to count things in terms of performance. And so with the basic statistical measures are a count of cases filed and disposed, how many cases assigned to a judge, by case type and by time period, and the number of dispositions by a judge. Because even though a judge may have exactly the same number of cases as someone else, their cases might all be complex. How do we balance that so that a judge is most effective with the cases that are in front of them? And we used some data from fiscal year 2023, and we see really simple, basic information, but we can look at this across the entire court in the entire state and say that in 2023, they had about 98% clearance rate. What Vida's measure of clearance rate, where she said if it's below 100, that court is probably increasing their backlog. But we look further and use data to tell a story, what happened is those filings increased during and after the pandemic. And if you looked at this over 10 years, you'd probably see that the filings were much more consistent with the way they are today before the pandemic, and then they dropped, and now they're coming back up again. That's a really interesting story, but it's an interesting story in terms of the stress it puts on the court and on the judges, because the cases are increasing. You can see the response to it in fiscal year 22, and then a sort of flattening of their response in 23. And we call this stress, or, you know, trying to sort of ascertain how the court moves through these demands coming externally. And then we talk about workloads in terms of, we were just talking about this complexity. And when we assign judges cases and when we decide how many judges a particular jurisdiction, it's not just a matter of counting all the civil cases and counting all the criminal cases and putting them into a bucket. It is weighting them according to the complexity and the demands that are placed on the judge. And this is where the issue of contested and uncontested is so critical, because a case that doesn't end up going to trial often puts a lot less demand on the judge. How do we count that, especially at the beginning of a case? So you can see the math on here. You can take a look at it later. But the difference between a simple infraction, a simple nonviolent case, criminal case, you know, this is not weights that we're recommending. This is just a comparison of how different the impact is on judges and how we need to agree to all of this. And this is a court in Louisiana and New Orleans, and we literally assign cases based on a percentage of each of these tracks, which are cases that are really defined often by complexity. And the big thing to see here is that you have, for instance, Division A is the chief judge. So that judge has a different weighted caseload than other judges. VITA presented 5 or 6 different performance measures used by CEPEJ. It's really important to understand that there are basic performance measure tools that are available. The court tools is something that's promulgated by the US system, the National Center for State Courts. IFCE has a set of tools which mirror to some extent, but also add other measures, the International Framework for Court Excellence, and then CEPEJ, which are the EU measures. The time standards are something that is IFCE and National Center for State Courts as court tools. They are the 98th percentile case usually, or the 100th percentile case. They're the longest case standard as opposed to the median. CEPEJ tends to use a comparative analysis across countries for the median case. And the reason they do this is because a lot of courts don't measure the time, and there are a lot of disagreements of how you do that. So they use something which they can take pending and disposed as a ratio and get at the average. And the average does not tell you a lot of information about really old cases. So they have been working on this case backlog measure, understand cases that are more than 1 or 2 years old, which is a looser definition that you would get from, for instance, the IFCE or National Center for State Courts. And then duration of pretrial custody is an international framework measure that is really now starting to be recognized in the US, because there's a lot of focus on people that are being held in jail before their trial who are not a risk to the community or a risk of committing another crime. And then finally, the 8th one, court user satisfaction, is really ultimately what this is about. How do we measure that? That's hard to do. It takes a lot of work. So when we're looking at some of these performance measures in terms of time standards, I just talked about the time standards in U.S. courts and the established timeframes. There is a standard that is recommended by all of the state court administrators and the chief justices across the United States. It is not necessarily adopted in every state in the United States. And then there are standards that have been adopted in other countries. CEPEJ uses the median case time as the normative comparison across countries. When we think about time standards, one of the gaps we see is that the procedural codes, you can see the code references below, in a lot of countries, don't want to impose a standard on a judge, for instance, for trials. So there's gaps. So what happens is the culture, the legal culture within a court, starts to define that based on how active or proactive a judge is as compared to reactive and letting the attorneys drive or the lawyers drive the duration of a trial. And I jumped right in divide this country here and showed the efficiency in terms of the average time on civil, criminal, administrative cases as compared to the European median. And again, these need to be taken with a real understanding of what's being described here. So often, second instance courts in Europe are cases which are appealed and tried again. Whereas in most British common law courts, an appeal is usually on the law or the procedure and not on the merits. So it's a very different standard in terms of thinking how long it takes for a case to go from the first instance to the second instance and then ultimately the highest instance court. But Lithuania is a very high-performing court by comparison to the European median. And then we use an example of model courts in Sri Lanka. These has not been adopted countrywide, but these 23 model courts have started to adopt time standards, and they do it in a similar methodology as we were using in IFCE and the court tools, which is organizing cases by complexity. So it's like those jars of preserved vegetables, is we put them into logical groups that we all can agree upon. And as an example, the difference between a simple criminal case and a complex criminal case. And this judge in a high court criminal case, criminal court, set a 98% standard for simple criminal cases and a 2-year standard for all of his complex criminal cases. And then the duration of pretrial custody. This is a really important measure in IFCE. And it is an average elapsed time that defendants are sitting in jail awaiting trial. So in the US in 2017, they, in New Jersey, instituted bail reform. And one of the drivers of it was realizing how long people are sitting in jail. And the measure they used was whose monetary bail amount was very low, but they were so poor they couldn't get out. So we were holding them in jail because they were poor, not because they were a threat to their community or because they were not likely to show up for court. And when they instituted bail reform and eliminated any form of holding people under a money bail system, they found that the crime did not go up and the appearance rate of the accused in criminal cases stayed the same. It did not go down. The case backlog, IFCE has a very nice measure of it, but I like the last phrase they used, and they literally use this in the measure, the proportion of pending cases that have already taken too long. And there's a nice tone of frustration in the way they describe that. I thought that was pretty apt. And so we looked at the commercial high courts. These are very, very high value commercial civil cases in Sri Lanka. They have a specialized court for this, and looked at how many cases were old. And they set a standard for themselves of ultimately 2 years for these cases. So this is a little bit distorted, but at the time we were using the National Center for State Courts court tool standard of 1 year on a civil case for most of them. So at that point, they had 1,126 cases that were older than the 1 year standard across 4 judges. It's a specialized court. There's 4 judges for the whole country. And then trial date certainty. Trial date certainty is an important measure, and it's used differently in the US than it is in CEPEJ and the EU and also in IFCE and other countries. And that is that an event happens when you expect it to happen and something happens at that event. These are meaningful events. One of the difficulties of this is, well, people say, well, why can't you just count the number of postponements or continuances of a trial date or a pretrial date? You can't always, because the lawyers don't always tell you. They show up to court and they say, Your Honor, our witness is not here. And the case is reset, but it's not set, it's not defined in the case management system in the technology as a postponement. It's defined as a trial event that didn't happen. Nothing happened. So we're very careful about really defining what we mean by trial date certainty, that when a trial is set, that something advances in the trial. A witness is examined, there's cross-examination, there's direct examination. And that's a very important measure and often very difficult to get at because what's in the entry of what the clerks put into the system isn't always reflective of what really happened in court. And then we look at the number of events on a case. So what we discovered in these commercial high courts is that there are a lot of events on a case, but many of them are not, they're purely events set, they call them calling matters, to schedule a case. So if it's a postponement, they will reset it to schedule the next trial date. These are the kinds of things that can slow down a case and really create problems for the judges because there's too many cases that are being set on the calendar, too many events per case that are not meaningful for the advancement of the case. And then cost per case is a very difficult one also to get at. It's done very well. We'll show you an example of that here in a second, but is averaging the cost of a case based on, in the World Bank doing measures, business measures, does this very well, is how much does it cost a litigant to take a case through resolution or disposition. We did this in Sri Lanka, and it doesn't sound like a lot of money to litigate a very complicated commercial case, but in Sri Lanka, this was a lot of money that they were spending on these cases that had many, many events in court. And then court user satisfaction. This is so important. And one of the ways in which we look at this was done in Myanmar before the coup, is they were doing this very effectively. They were measuring every quarter in every trial court. And what was astonishing was the difference between a witness or a litigant's for understanding of what the court expected and the lawyers who obviously come to the court every day. This is very, very important. And finally, for each case, what is the judge seeing that's helping the judge understand the dynamics of what's happening on this case so that they understand, for instance, on this case age of 75 days, how old this case is when they appear in front of the judge. There are little tools you can put into the case management system, how many events have been held on this case, that are incredibly helpful to a judge to be able to respond to the lawyers and the litigants in front of them. And now I'm going to turn it over to Vaida to talk about the role of digital tools and software in case management. Thank you.
Thank you, Tim.
So now I'm taking the floor and I will try to fit in time. Sorry, we have so much ideas to share with the audience, so that's why it's a challenge to be properly in time. Now I'll try to use PDF file. Is it okay now? Can you see?
Yes, but it's not exactly right.
I'm sorry, what's
Can
wrong?
it's
It's
not
the
in
added version.
presentation mode.
It's not the full screen.
Oh, not the full. I'll set the full screen, so it's a minute. Wait a minute, and now it's okay. It should be no.
No, nothing's changed. There you go. You're good.
There you go.
Okay, so now I'll try to share some insights on how the digital tools and software technologies might help in case management. And during today's presentations, we stress the importance of digitalization process, not only for effective operation of the course, but also for being able to assess its operation and come up to particular decisions. But before diving into specific IT instruments used in case management, I would like to emphasize one point from my perspective. It's very important in discussing of any digitalization ideas is that digitalization or using of digital tools is not just a technical upgrade, it's also a mindset shift. It means that It's a commitment to use and to work and to have standards how to work using digital tools. We need a common understanding. We need to actively promote and communicate about the necessity to have digitalization processes within judiciary. And what core advantages of this process, and which might feel the judiciary and the common society in general, is that faster case processing. For sure, digital tools automate routine tasks, reduce paperwork, and minimize delays, making justice delivery more efficient. Improves transparency and public trust. Digital records, online access to decisions, and audit trails reduce the risk of corruption and builds confidence in the system. The other advantage, the benefit of the process is the enhanced access to justice. E-court platforms allow the public and legal professions to file documents, track process, and engage with the court without needing to appear in person. Better resource allocation. It's very important to use the benefit of digital tools in order to lower the necessity of human resources. Also to follow the modern practices such as AI employment in order to have some functions, manual functions, replaced by technological means. And also the technologies ensures stronger data security and protection. Without paper documents, we can work in a more secure system and can have a better control access of the data. Importantly, that these benefits extend beyond the judiciary. As I mentioned in the beginning, they have a positive impact for our clients, for government authorities, for sure for policymakers and society in general. But for digital tools to support truly the justice system, we must meet certain critical standards. And I say must because without these, even the best digitalization initiatives are likely to fail or remain in the paper form. Let me highlight a few key requirements. Is that all IT solutions used within the judiciary must evolve with modern technology. They must be up to date. And modern technologies now include like content management system, big data processing, AI-powered models, automation tools. The private sector moves quickly, and the public sector often struggles to keep the pace with the digitalization and adoption of IT tools in daily routines. That's why it's vital to have a well-managed national strategy for digitalization process and maintenance of technology, which should be supported by sufficient funding and long-term planning. So I may say that digital justice needs to be a policy priority, not only of the judiciary, but of the state government and legislative powers. The technology should be secure and stable, reliable. A system must be technically stable, protected from security threats, equipped with proper data processing and workflow functionality. Trust in the judiciary depends on confidence that digital operations which exist within the system are reliable, audible, and safe. So regular security checks must be planned, and they are essential. In all data flows should be traceable, and the attention for making the system reliable must be paid. Structural data use. It isn't just a goal, it's already or a future coming, it's a reality. Courts must move toward data-driven processes to ensure standardization. We talked about this in an hour before, in order to be able to use this data, reuse, and to make the court work more efficient. User-friendly interfaces for courts and clients. IT tools must be designed with users in mind, both court staff and clients. The interface should be intuitive, modern, follow best practices, be updated regularly based on feedbacks and user needs. So we cannot deploy the system and do not do anything in like a long period of time. We need to have periodical updates in order to encourage people to work and to feel the benefits of the system. And the last point is the commitment. I have already talked during my first presentation how it's important to have a commitment obligation to enter data. And the other aspect, the obligation and commitment to use technologies for storing data for court operations. And the support for this commitment should be in all levels, starting from technical, managerial, organization, and even in political level to promote. And one more very important point from my perspective is that to have more centralized solutions should be a priority because it enables to coordinate updates, shared infrastructure, better resource use, and to have the common standards within the whole judiciary for what type of technologies of what security level should be implemented. So as centralization processes enables to work more cost effectively for sure, and to have the more standardized procedures within the users. Now I'd like to turn a bit how judicial information systems or IT tools can be effectively used to support both the organizational and the performance assistance of court activities. The systems are not just for data storing, they enable administrators or responsible persons for smarter planning, also to make judiciary more transparent and operate efficiency. And the information systems might be used in various cases, starting from registration, storage of data of case examination, using for automatic allocation of cases, evaluation of court's performance, resource planning, publication of data, and for the exchange of data with other information systems. And now I will talk a bit about each. The first one, that IT tools help to have explicit information about the case examination, and explicit registration of both initial and ongoing case data plays a key role in the efficient organization of the entire examination process. This structured approach ensures that every step of the case is traceable and manageable, allows better planning, scheduling, and coordination across all involved parts. But the value goes further, for sure. When data is entered in a structured and standardized way, it becomes reusable. So once the process participants submit structured data to the court may reuse it in the other proceedings. So this means that the judiciary won't need to manually process paper forms or work with unstructured documents. By introducing structured data entry from the very start and enabling automatic registration into the system, we reduce administrative burdens at the same time and increase the data quality for sure. One more way of using empowering the IT tools is to use for automatic allocation of cases. For sure, automatic allocation using specific algorithms ensures transparency. The Lithuanian judiciary uses this automatic allocation of cases for more than 16 years. The automatic allocation of the cases enables to evaluate a broad scope of data and to find, to make the workload correlation between judges more equal. During this process, the systems enables to develop a broad scope of data, starting from the case data like type, category, legal requirements, case complexity score, to use various information about judges, including its specialization, holidays, declaration of interest, and various other groups, to have allocation history during the reporting period. When there is such a wide range of information, the automatic algorithm forms the list of judges. For sure, in this procedure, the random score plays a role. And when there is a list of judges, when the particular judge is appointed, the protocol is published widely. So we have like a publicity for the society in general that the assignment of case met the highest transparency requirements. Well, if there is a need to change a judge, the same procedure might be also used. I may share with you the form used by Lithuanian courts. This is a published protocol with names and sums of Lithuanian judges, but you see how many data is evaluated, how much data is evaluated during the assignment of one case. One more sphere where the case management systems might be used is to evaluate the performance of courts or judges. The systems might generate reports of judge performance using the data stored in the system. And the latest last year, and CPEJ released its guidelines on the evaluation of the quality of work of judges. And it stressed that during the evaluation process, there should be a balance between qualitative and quantitative criteria. That means that it's recommended for judiciaries to have evaluation based on qualitative and quantitative criteria. And for quantitative criteria, this is suggested to have the number of resolved cases during the reporting period, ratio between received and resolved cases, the duration of proceedings. But also in this report, the complexity of cases must be reflected and evaluated, which also has to be in mind during the evaluation of judges' performance. That's why here you can see also the example of a document used by Lithuanian courts of for judges' performance evaluations. And here we store a wide range of data in order to have a broad view of the cases which a judge deals with. And for sure, we have a qualitative criteria of a judge's performance, but to have the statistical, this quantitative view, we follow the CPEJ practice, and the IT tools help us to have this reports. Evaluation of courts performance, so reports on evaluation of the various courts activity experts, as we talked today during my first presentation, the disposition time, clearance rate, workload calculations. During the workload calculations, there's very important to evaluate the complexity of cases. And here I would like to share some practical examples how the Lithuanian judiciary uses the data stored in our information system to provide public information of the various courts activities. Here we can see the changes of the numbers of cases which were assigned to judges in particular instances, of course, the changes of the workload, the changes of case processing durations during the last year, how the mediation processes affected the case examination on various aspects. The system enables also storing a particular data enables to analyze the separate groups of cases in very detailed aspects, how the changes, the numbers of this type of cases changes during the years. One more use case of the information systems is for planning the resources. Today I have shared a bit about how it's important to have a case weighting system, and the system should be based on courts data. And using having this having enough data, we can rely, we can create various decisions. So using the case weighting model, it becomes a very powerful tool for judicial resource plans, how many judges are needed per court or per case, staffing decisions, determining the number of types and types of what personnel we need for the judiciary to be effective. For budget planning, for instance, the Netherlands use the case weighting system and courts information systems data for planning the budgets for coming years. So it's very modern practice to do this. And also how much other infrastructural resources are needed for the courts to operate efficiently. One more possibility of IT tools for sure to publicate courts data on various formats. Publishing court data, having open data policy, judiciary demonstrates its transparency responsibility toward the public. But the publication of data might be done using various IT tools in national and international forms. So here you can see the example of national dashboards and CEPEJ dashboards, for which is formed by the data provided by the national member states and their information systems. So having the dashboards or publishing the various courts data, we create we make our judiciary more transparent and accountable, as Tim said, to the society in general. And one use case for the information system is also to provide information for other information systems. So to have real-time exchanges and improve data integration with other information resources really directly influence the operational effectiveness of the other state institutions. And to have two-way exchange also is a really good solution, well, effective solution for making the operation of a judiciary more effective. And well, for sure, minimizing any exchange of paper form information. So my suggestion and recommendation for the judiciaries to employ information and technologies, IT tools for effective operation as much as possible, and we'll see the benefits in really short future for how these technologies might help to save resources, to have more transparent system, to make processes better, and just to have get better results in case resolutions and administration or justice in general. So thank you.
Oh, thank you so much, Vida. We have a couple of questions. This one is from a participant. Is the consideration of an application for reversal of a court decision, appeal, I assume, considered a continuation of the legal proceedings, or is such consideration considered a new legal proceeding? I think you both could answer that, and we might get a couple of different answers. Tim.
So in looking at measuring time, one of the interruptions of a court case is an appeal of an interlocutory order, an order by a judge before the case has been resolved. And we would, if it depends on the jurisdiction, but if the appellate court stays the lower court case, that case no longer is counted in terms of time, and the case is in suspension. In other courts, the court may not stay it. It may be an appeal on an interim order, and the court can go ahead and move forward. So either one of those are differently. The appeal itself is a different case. Yeah.
Sorry, Vida, would you have anything to add to that?
I agree with Tim that the appeal case is a different case, and we should measure it in a separate manner.
We have another question. How is access of the participants of the process to the case materials provided in the courtroom? Is there a specially allocated time or any time during the court's work?
Ida?
Vida, would you like to answer that first?
As I have from a practice that the time which is necessary for a person to acknowledge to the information during the proceeding in the courtroom is encountered in a court hearing time, and often, well, during the preparation phase, judiciary tries to create all possibilities to access to all information which is provided during the proceeding. But if during the hearing appears that there is new information, all parties must know it, and the process should be, well, prolonged in this way for the making possibilities to get all the necessary information to know it.
Tim, do you have anything to add?
Sure. I mean, again, it depends. And so traditionally, if a litigant or a lawyer wanted to get access to information from a case, they had to go to the clerk's office or the registrar's office and get a copy of a paper, parts of a paper file. Today, there's a lot more automation involved. So a lot of courts provide access to information about the case online, but usually it is fairly restricted. And the litigant themselves can often get more information, for instance, than somebody from the public. In the courtroom, again, it depends. If the court has a sophisticated case management system and they're able to give access to the lawyers to parts of it, but where they don't have any control over what's entered into the case, they often do that because the lawyers don't always have good case management systems.
Thank you. So in conclusion, by pooling our knowledge and expertise, it is our hope that we can help develop actionable solutions to support the future of our courts. We must always look to strengthen the foundation of our justice systems in order to serve the people who enter our doors with distinction and timely justice. In conclusion, thank you to our presenters, IACA, EU Pravo-Justice, and the State Judicial Administration of Ukraine, and notably to all of you for joining us today. I have great respect for what you all do every day. I also have exalted respect for our Ukrainian counterparts. I can't even imagine how difficult your jobs are at this time, but I also know this: without your talent, dedication, and long-term commitment to the rule of law, society would suffer. Thank you for your perseverance and steadfast commitment. It is dearly needed, especially at this time. With that, I will conclude this webinar and thank all of you, and we look forward to seeing you again. Thank you.